I'd like to welcome now in Dallas, Texas, former DOJ senior attorney and former federal prosecutor Tammy Allison. Tammy, always enjoy having you, but what a perfect time for you to be on because you are so familiar with the federal system and what this case is all about. So tell me, first of all, how you would just translate, and Chanley did a great job breaking down all of the laws that apply in this particular case, but how you would describe the civil charges that these three ex-officers are facing.
Yes, thank you so much for having me, Ashley, as always. The way that I would explain it to the viewers is these charges with this specific statute in which they were charged under with a federal civil, which is different than the criminal trial. The civil means that they willfully allowed Derek Chauvin to do what he did, as we know, put his knee in George Floyd's neck for 9 minutes and 29 seconds without doing anything about it. Because they are public servants, police officers, they have a duty to intervene. But as Chanley stated, that burden of proof is going to be beyond a reasonable doubt. And one of those elements is the willfulness. These officers, as we've already heard in the prior trial against Derek Chauvin, where he was found guilty, we heard that those officers were subordinates of Derek Chauvin. So that willfulness is going to be something that's challenging. I know that there's a verdict out, but we don't really know what the verdict is yet. So that's going to be very interesting, especially considering that willfulness that is necessary in order for them to meet that very high standard of beyond a reasonable doubt. In these types of situations, whenever there are officers and there's an excessive use of force, typically what I see is something that is brought under Section 1983 as opposed to this statute, where it's similar, where it's a deprivation of civil rights under the color of law, but it doesn't necessarily have that willfulness standard that is very high to me.
It's interesting you say that because I always think of 1983 claims as well. I want to go back to the burden of proof because I just want to clarify and make sure for our viewers, a criminal trial in which you are trying for any criminal charge, it's always beyond a reasonable doubt. Is it also, given this is a civil case, federal charges, Tammy, did I hear you say this also is beyond a reasonable doubt and we need a unanimous verdict from this jury?
Not necessarily. As we know, during criminal trials, the standard of proof is beyond a reasonable doubt. For this specific case, because it is civil, there are going to be different things that are in place, not necessarily beyond a reasonable doubt, but with a jury, they do have to unanimously agree that that willfulness is necessary. And that's going to depend on the specific jury instructions that the judge provides to the jury.
And we know from Chanley that she got her hands on those today and reported out earlier, 40 pages. That's how long those jury instructions were. So knowing that those were 40 pages, knowing that there are three defendants, three of the defendants face the 14th Amendment violation charges, the other two of them face the other charge that has to do with the unreasonable seizure. We know that this is day 21 today. We're on day 2 of deliberations. Having some of those pieces, those numbers, by the numbers, so to speak, are you surprised that at 13 and a half hours, a verdict is in?
You know, I'm never surprised with these types of situations. Federal court is a completely different beast than what we see in state court. Federal court is very streamlined, it's organized, it's by the book, and the rules of federal civil procedures are typically followed to a T. So as long as the jury had instructions, they were properly conveyed to them, it shouldn't be of any surprise that the jury has already come out with a verdict and we don't know what it is. But given the fact that the federal system, is so very organized and they really follow those rules of civil procedure, it's not surprising to me.
I always say federal court doesn't play because it's more formal. I've tried cases in federal court, and it is a much different environment, to your point. And I agree with you, streamlined, efficient. They just don't play. They're going to get the job done. So we are waiting. We're on verdict watch. While we're waiting, we're going to take a break. You're going to stay with us, Tammy, to continue to talk about this. Verdict watch. As soon as we get this verdict in the killing of George Floyd in the civil case in federal court, remember, there are no cameras allowed, but we'll bring Chanley in as soon as we have that verdict.